come to order. My apologies for coming in a few minutes late, but Senator Graham and I were in the Appropriations Subcommittee on Defense with the Secretary of Defense and ran over a few more minutes. I believe I speak for all of us with the feelings of relief and support for our colleague, Senator Feinstein, who has returned to Washington. I know that she's been through some significant health challenges, and we all wish her the very best. We have a number of items on today's agenda, including 7 judicial nominees who have previously been held over. I intend to call them shortly, and if Senator Feinstein arrives, we may be able to take up those additional nominees very quickly. The first nominee we're going to vote on today is Jeremy Daniel, nominated to the U.S. District Court for the Northern District of Illinois, rated unanimously well qualified by the American Bar Association. I could recount his service to our country in the Marine Corps and all of his work with the U.S. Attorney's Office and other agencies, but I think most of you are well aware of it. We also have 4 bills on the agenda that relate to the critically important issue of online safety for our children. S. 1199, the Stop CSAM Act, S. 1080, the Cooper-Davis Act, S. 412, the SHIELD Act, and S. 1170, the Project Safe Childhood Act. After we consider nominations, we will move to the Stop CSAM Act, which would make critical reforms to better protect our kids online. Since I released a discussion draft of the bill in February, my staff has reached out to every office on the committee and to outside stakeholders to solicit multiple rounds of input. I believe this is a critically important piece of legislation, and I invite the committee to join me to make it better if possible. I think we can. I intend to offer a manager's amendment that addresses the issues that have been raised, and I'll further discuss the bill when we turn to it. With that, I turn to Ranking Member Graham.
Thank you, Mr. Chairman, and I too want to welcome Senator Feinstein back, and glad to have her. As to the legislation you just indicated, we've been working well, I think, with you and your team, and we have some amendments that I think will perfect the bill. This whole idea of protecting children from online predators and having images used that follow them to the grave is a worthy endeavor, and we have some amendments that we think will make the bill better. We will continue to work with you and our Democratic colleagues, see if the committee can come up with a package that could go eventually to the floor and show the public that we not only are concerned about social media abuses, we're actually going to do something about it. And so I look forward to this continued effort.
We're waiting for the arrival of one of our members on the Democratic side so we can move to votes on the nominees. So I will, at this point, open the floor to anyone who'd like to make a comment on it.
You can make your statement on the bill now, if you want to do that.
That's a good idea. I'll go ahead and make the opening statement on the bill while we're waiting for Senator Blumenthal to arrive. The Stop CSAM Act of 2023, I described this last week, as a bill that took many meaningful strides to stop online child sexual exploitation. The status quo, the current state of the law in America, is unacceptable. Let me discuss several key reforms that this bill would make. I've spoken to you about a woman named Charlotte. When she was a teenager, a person she thought was her boyfriend posted sexual images of her online. Since then, these images have haunted and stalked Charlotte at every stage of her life. Survivors like Charlotte need an easy-to-use system to notify online platforms when they are hosting CSAM and to remove the images, take them offline. This bill creates such a report and remove mechanism. I also talked to you last week about the growing number of cases of financial sextortion. That's when an offender tricks a child into sending a sexually explicit image and then threatens to circulate the image online unless the victim pays a ransom. In 2021, the National Center for Missing and Exploited Children, NCMEC, received 139 reports related to financial sextortion. 2021, 139. Last year, the number exploded to more than 10,000 reports. Earlier this week, USA Today told the story of James Woods, 17-year-old high school senior in Ohio, bright future ahead of him. He died by suicide last November after being financially sextorted and repeatedly threatened. His family is now raising awareness about the need to stop this crime. Under the Stop CSAM Act, platforms that promote or facilitate this conduct can be prosecuted. The bill also creates a civil cause of action for victims of child sexual exploitation against online providers that intentionally, knowingly, or recklessly promote or facilitate such exploitation. The Stop CSAM Act will also strengthen the cyber tip line, which is the way that online platforms send reports about CSAM to NCMEC and then to law enforcement. Last year, half of all the cyber tips provided by tech companies provided no or insufficient information to be actionable by law enforcement. This bill addresses that very serious problem by requiring cyber tips to include basic subscriber information and other publicly available information. If we are serious about protecting children and grandchildren online, it's time to create real mechanisms to hold providers accountable and to have providers do their part to stop the proliferation of CSAM online. I would like to now offer a manager's, Senator Blumenthal's here, so we're going to go back to script on the two nominees. Forgive me. First is Jeremy Daniel, nominated to the Northern District of Illinois. Does anyone seek recognition to speak on this nomination? If not, the clerk will call the roll.
Mrs. Feinstein.
Aye by proxy.
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye.
Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Ms. Hirona. Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff. Mr. Welch. Mr. Graham.
Aye.
Mr. Grassley.
No.
Mr. Cornyn.
No.
Mr. Lee.
No.
Mr. Cruz.
No.
Mr. Hawley.
No.
Mr. Cotton.
No by proxy.
Mr. Kennedy.
Aye.
Mr. Tillis.
Aye.
Mrs. Blackburn.
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 14, the nays are 7.
The clerk will report that to the floor. Next is Brendan Herson, nominated to the District of Maryland. Does anyone seek recognition on this nomination? If not, the clerk will call the roll.
Mrs. Feinstein.
Aye by proxy.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Mr. Coons.
Nominee having received a majority vote be reported to the floor. Now, returning to the Stop CSAM Act, I hope everyone's with me.
One more.
Oh, I'm sorry. Darryl Papillon, nominated to the Eastern District of Louisiana. I'm sorry, Senator Kennedy, that I overlooked that nomination. Is there any comment from the committee? If not, the clerk will call the roll.
Mrs. Feinstein.
Aye by proxy?
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye.
Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Ms. Hirona. Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff. Mr. Welch. Mr. Graham.
Aye.
Mr. Grassley.
No.
Mr. Cornyn.
Aye.
Mr. Lee.
No.
Mr. Cruz.
No.
Mr. Hawley. Mr. Cotton.
No by proxy.
Mr. Kennedy. Mr. Tillis.
Aye by proxy.
Mrs. Blackburn.
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 15, the nays are 6.
The nomination will be favorably reported to the floor. Now, back to Stop CSAM, if you'll bear with me for a minute. Section 2 of the Stop CSAM Act requires entities that receive $10,000 or more in discretionary federal grant dollars to provide any services to children to report child sexual abuse when they become aware of it. Under current law, bear with me for a moment here. Under current law, organizations that provide services to children outside of athletics are not required to report child sex abuse. In other words, there is mandatory reporting for the Little League, but not for the Cub Scouts. Now, I understand there are concerns on the other side of the aisle about potential unintended adverse impacts on mandatory reporting. I've made a number of changes to the bill to accommodate these concerns, and I'm happy to continue to work with my colleagues on this after the bill is reported. Before I offer the manager's amendment, I'll recognize Senator Graham to speak.
Thank you, Mr. Chairman. Yes, there has been a real effort to find consensus here and make sure that what we're doing doesn't hurt people with religious beliefs and organizations that can't be, taken in the wrong direction. So I have an amendment, OLL 23435, to strike Section 2 of the bill, and I'd like that to be called up if possible. And this is a result of negotiation between people on our side and your staff and others to replace Section 2 with something that we think we can all better live with. And to the members on the Republican side, if I've misstated that, please say otherwise, but I think we're in pretty good shape with this amendment.
So before calling your amendment, as I understand, we are going to continue our discussion to see if we can find common ground, and I hope we can. This is an integral part.
I thank Senator Lee and Cruz and others who really weighed in here to make this better.
So the question is on the adoption of Senator Graham's.
To move the manager's amendment first.
Okay, let me take it in order. I'd like to offer a manager's amendment, which is Amendment LYN 23293, and I'll move to adopt the manager's amendment. All those in favor say aye.
Aye.
Aye. Those opposed, no. The majority of members present having voted in the affirmative, the ayes have it. The manager's amendment is adopted. And now I believe it's Senator Graham's amendment.
Yes, Mr. Chairman, I would urge adoption of this amendment. I think this makes the bill much better, and we'll continue to work to improve problems we have, but this would be a giant step forward.
The Graham amendment is OLL 23435. Is there any discussion on this amendment? All those in favor say aye. Aye. Opposed, no. The opinion of the chair, the ayes have it, and the Graham amendment is adopted. Now we'll turn to consideration of other amendments. In a moment, I'm going to turn to you, Senator Hawley, to offer an amendment on which you and I have reached an agreement. With adoption of our agreed-upon language, I understand you will co-sponsor the Stop CSAM Act. Senator Hawley's amendment would address the liability that applies under the bill when providers knowingly host or store CSAM or make it available. We've been trying to strike the right balance between penalizing this misconduct while not deterring providers from scanning their platforms for CSAM and quickly reporting and removing the offensive material when they find it. I thank Senator Hawley and his staff for working closely with my staff on this amendment. Together, we've developed a second-degree amendment that preserves the liability while refining the affirmative defense that responsible providers can use. The second-degree amendment also revises a rule of construction concerning what evidence is needed to prove that the provider was knowingly hosting or storing CSAM or making it available. I now recognize Senator Hawley.
Thank you very much, Mr. Chairman. I want to thank you for your excellent work on this and your continued work on this. I have, since I've come to the committee, been urging the committee to take action to take on CSAM and to get it off of the internet to protect our kids. Obviously, this featured prominently in our Supreme Court confirmation hearing last year. The chairman and I have had many discussions about this over the last couple of years, some of them more tense than others, some of them on the Senate floor, some of them here in the committee hearing, but in the committee room rather. But that's really one of the reasons I'm particularly grateful to him for forging ahead with this. And I just want to emphasize one portion of this bill that I think is critically important, and that's Section 6 that the chairman was just alluding to, civil liability provision. And for the first time, it will allow victims of this material to get into court and to sue the people who made it, but also those platforms that knowingly host it. And I've become convinced in my short time here, having watched the FTC fine Facebook, now Meta, they blow it off and do nothing, and they slap this other company on the wrist, they blow it off and do nothing. I've just become convinced that maybe the only way to get the attention of these platforms is to give individuals the right to get into court and to have their day in court. And frankly, that's just an old-fashioned American principle, that you ought to be able to get into court and have your day in court. And I think that's the way that we're going to achieve real change here and give real power back to the victims and get justice for them. So I think that for that reason alone, Mr. Chairman, this is an important bill, Section 6. You and I have agreed on some language that I think strengthens it while preserving that balance that you talked about. And so now, with your permission, I'll call up my amendment.
Mr. Chairman,
Senator Blumenthal.
I agree 100% with Senator Hawley, and I welcome this bill and this amendment. I think it performs a really important goal, and it is exactly the same goal that Senator Graham and I sought to advance in the Earn It Act. We have total agreement on this effort to hold the big tech companies and platforms responsible, accountable, and cut through the Section 230 immunity that they now have so broadly. And I think it's consistent with what Senator Graham and I have been trying to do, and I think it is the thrust of the future, and big tech ought to wake up and recognize they're going to be held accountable and ought to be by the individuals who are harmed. And whatever we think about the FTC and about other government enforcement agencies, plainly, they haven't been doing the job. And I welcome this proposal, and especially, Mr. Chairman, your willingness to continue to work together on it.
Thank you, Senator Blumenthal. Anyone else seek recognition?
Mr. Chairman.
Senator Graham.
This is sort of a breakthrough moment here. We've had a couple in this committee, the Earn It Act, but what Senator Hawley has been able to work out with you is a giant step forward, allowing people to do something that most people in America are amazed they can't do. If somebody is ruining your life, there's nothing you can do about it. If you get run over by a car, you can sue the person that ran you over. You know, it just amazes me that in 2023, that we're still in a position where the social media outlets and these sites can destroy a person's life, and there's just nothing individually you can do about it. Well, those days are just about over. So in the 1990s, it made perfect sense, I guess, to give Section 230 immunity so these technologies could emerge and become vibrant. I would say they have become vibrant. They've become out of control. They're the most profitable businesses on the planet. You can't sue them. There's no statutory scheme in place today that would regulate their behavior, and there's no agency that overlooks their shoulder to protect the consumer. So I'd like to do all three. I'd like to have a commission of some sort. I'd like to pass your legislation, the Earn It Act. I'd like to do all that, but we're probably not going to be able to do all that. So here's where I'm going next. Section 230 has outlived its usefulness. I will be introducing with Senator Whitehouse and hopefully others legislation to sunset Section 230 in 2 years, giving us a chance to find a better answer. They will never deal with us, the social media companies, honestly and openly until we put Section 230 on the clock. I intend to do that, and I'd like your support when that day comes.
Thank you, Senator Graham. I'd like to offer the second-degree amendment to the Hawley Amendment, OLL.
Hawley has to call it his amendment.
I'm sorry, Senator Hawley has to go first.
I'd like to call it, Mr. Chairman, my amendment, which is OLL 23485.
And I offer this Durbin second-degree amendment to it, and all those in favor say aye. Aye. Opposed, no. Majority of members present having voted in the affirmative, the ayes have it. I now move to adopt the first-degree amendment as amended. All those in favor say aye. Those opposed, no. The majority of the members present having voted in the affirmative, the ayes have it, and the amendment is adopted.
Mr. Chairman, could I ask now consent to be added as a co-sponsor to your bill?
Without objection. Does any other senator seek recognition to speak or offer an amendment?
Mr. Chairman,
Senator Blackburn?
yes, I'd like to call up my amendment, OLL 23481.
Do you want to explain your amendment, please?
Yes, I'll be happy to go ahead and explain it while you find it. This amendment would strike Section 7 of the bill, which creates the Child Online Protection Board that is housed within the FTC. I agree that creating a notice and a takedown program is a laudable goal, and it is one I'd like to work on to make certain that we achieve that goal and protect our kids and get this stuff off the internet. But I don't think that this bill's approach is correct, and that's why I suggest we remove it with a commitment to work together to find a solution. Now, what we do know is NCMEC has a new service. This service is called Take It Down. They launched this service a few months ago so that they can help people get CSAM removed. NCMEC assigns a hash value to each reported image, and online platforms use these values to detect and remove CSAM. NCMEC can track how long it takes the providers to remove the offending content, and they follow up with them when they don't remove it and make certain that that content gets pulled down. And this program launched in February. Since then, it would be useful to hear from NCMEC about how this is working, what they have seen as the effectiveness of this program, what they think should be changed, what should be updated, and how they can coordinate with Congress to make this even more successful. Instead, this section creates a new administrative entity within the FTC. The FTC is not equipped to house this type program, which is far outside its mission. The FTC mission is preventing business practices that are anti-competitive or deceptive or unfair to consumers. This section would expand the FTC's authority to include child protection officers on its staff. And on this committee, on Commerce Committee, we often talk about the FTC and how it is overstepping its authority left and right. So why would we literally expand their role into law enforcement, particularly when DOJ can do this job more effectively, and when NCMEC already has a program that they have launched that is addressing this, and we need to look at that program and see how effective it is and how we can most quickly get this stuff off the internet. And I really appreciate the conversations that our staffs have had on this issue. I look forward to continuing to work with you on this initiative so we can make certain that the CSAM Act is buttoned up, ready to pass, ready to be signed into law, but ready to be effective. Bringing the FTC into this is going to confuse the issue. Thank you, Mr. Chairman.
Thank you, Senator Blackburn. Section 7 of the bill, which this amendment seeks to strike, is the Report and Remove program. It is an essential component of the bill. Report and Remove provides victims with an easy-to-use, enforceable mechanism to request removal of child sexual abuse material from an online platform. Remember Charlotte? Spending her whole life trying to find out who to contact to take this information off the line and put an end to it. This is one of the most direct means of dealing with CSAM online, empowering victims who appear in or harmed by this imagery. Section 7 creates a system which allows victims to request removal and then seek adjudication before a board of providers' refusal to remove the images. At the same time, it includes safeguards to provide providers and legitimate content owners, protect them from malicious takedown requests. It imposes appropriate fines on providers who fail to timely remove CSAM or request adjudication once it's reported. We've spent months trying to strike a balance here, And at this moment, we have struck that balance, and I hope we can maintain it. We have the support of the prosecutors. We have the support of Fraternal Order Police. We have the support of victims' organizations. We have finally reached a point where we believe this is as balanced as we can reach in this undertaking. Taking out Section 7 is taking out a central part of this whole effort. I have been working on it for months. I'm willing to continue to work with Senator Blackburn on the exact language, but I would oppose this amendment and hope my colleagues on the committee will join me in that opposition. Does anyone
Mr.
else?
Chairman?
Yes.
In response to that, the takedown and removal, the report and removal is not the issue. You need the ability for that. I agree with that. The concern is standing up a new agency delays getting this to happen because you're talking about putting it at the FTC. NCMEC and DOJ already have this process. Let's get this active as quickly as possible. They're already doing this. NCMEC is doing this. And I will withdraw my amendment. If you will work with me on this, why would we confuse the issue with a new agency? Let's see what we can do to use existing resources to make this happen as quickly as possible.
Senator NCMEC supports the bill as written, but I want to work with you because if there's any way to improve this, I'll do it. And if you wish to withdraw the amendment based on that promise, we'll do that.
I will be happy to. I just think what we need to do is review what they're doing before we look at standing up a new entity. What if it takes them 6 months or a year to do that? NCMEC has this process in place. Let's expedite the removal of this harmful material.
Mr. Chairman?
Mr. Chairman.
Senator Graham?
Okay. So, number one, this is a very good discussion to have, and here's the question I have. I'm going to support the bill, support Section 7. I hope you can work with Senator Blackburn to make it more effective. The question for us all, is the FTC working when it comes to regulating social media? Is there any belief that the FTC can bring these people to heel, given their past record? And if you really want to go after, have an agency to look over the shoulder of social media, is the FTC equipped to do that? Do they have the personnel? Do they have the resources? That alone would be one of the most monumental tasks of any branch of the government, any agency in the government, is to ride herd over social media in the areas that we've all talked about. So the one thing I want to urge the committee to do is understand that where we're at today, nothing is working. The FTC is not working. Your bill I will support because it moves in the right. I support my own bill, the Earn It Act. The bottom line is the only way, Mr. Chairman, I think you're ever going to get any law passed is to make the social media companies fear losing the liability shield. And if they don't fear that, they will beat us all. And the regulatory process we have today is a joke. They'll gladly write the check and move on.
Mr. President, or Mr. Chairman, rather.
Senator Kennedy.
Mr. Chairman, I'd like to call up First Degree Amendment, Amendment ALL 23296.
Mr. Chairman, before we turn to that, can I just make one brief addendum to our last discussion?
Senator Kennedy yield for that purpose?
Of course.
Senator Lee.
I'd just like to be involved in that effort as well. I agree with Senator Blackburn on this. Want to make sure that people have a way to get it removed. I just don't think this new entity, this new board within the FTC is the way to do it. We could do that through DOJ. I'd love to work with you on that. Thank you.
Thanks, Senator Lee. Senator Kennedy?
My
Explain your amendment.
amendment will deal with evidence. Other agencies certainly may not be doing their job, but our FBI is at least trying. And right now, if the FBI sees, let's say, child pornography on a social media platform, the FBI, and we passed this law, by the way, 2 decades ago, the FBI has to go to court to get a subpoena to gather the evidence. Now, Oftentimes, the social media platforms have agreements with users that say, if we're served with a subpoena to turn over your information, we have to tell you, the user, about it. Well, the alleged child predator does what is predictable. He starts destroying the evidence. So we changed the law to say, look, you've got to, the social media platform, cannot tell the user for 90 days that this subpoena is in the process to keep the user from destroying the evidence. My amendment would make two changes. Number one, now the FBI, under this amendment, could issue an administrative subpoena to the social media platform. Give me the pictures. The social media platform could choose to go to court. Social media platform would not be required to go to court. Most of them would go to court. But the burden is on the social media platform. Number two, while the FBI is in court getting the pictures, the social media platform cannot tell the user, the alleged child predator, for 180 days instead of 90 days. Because sometimes the court process takes more than 90 days. And not always, but in many cases, the user, once he finds out there is a subpoena, is going to start destroying evidence. And that's all my amendment would do, is try to help the FBI.
Senator Kennedy, I think you make a valid point. My staff and I may disagree on this, but I'd like to work with you on the language, if you don't mind. I think this question of the judicial review and when it should take place and how long a grace period without enforcement would last is a worthy issue I'd like to discuss with you.
Let me be sure I understand, Mr. Chair. Your staff doesn't like my amendment, but you do?
I think they're warming up to it.
Well, if I were you, I'd overrule them. That's just a suggestion.
I'm trying to spare them any public embarrassment.
But certainly I'll agree to sit down and work with you and your
Let's do it.
and your staff,
And you'll withdraw the amendment?
and I will.
Well, you have my word that we'll do that. Are there any further amendments to be offered?
Mr. Chairman,
Senator Cruz.
I'd ask unanimous consent that I be added as a co-sponsor to the bill.
Senator Cruz will be added as a co-sponsor to the legislation. So if there are no further amendments. Senator Coons.
Thank you, Mr. Chairman. I want to thank you for your continued work to protect children from abuse, both online and offline. And as you've acknowledged, part of the solution here is greater transparency by platforms. And I appreciate the movement in that direction by the Stop CSAM Act. I think there's ample room to build on that further. I filed an amendment to the bill that contains the language of my Platform Accountability and Transparency Act, which would do just that. I am withdrawing the amendment and will not seek a vote on it today. But I did briefly want to reference that this bipartisan bill, co-sponsored by Senators Klobuchar and Cornyn on this committee, would move us significantly in the direction of platform transparency. It would allow researchers to submit applications through the NSF for projects involving the largest social media companies. If approved, it would provide researchers with a narrow legal safe harbor from lawsuits that may be launched back at them by the platforms, and require platforms to disclose to the public basic information about how their algorithms do their work, how they do content moderation, how they deal with advertisements, viral content, and would allow us to have neutral, nonpartisan, deeper understandings of the impact of social media. I think we need more information about what's happening on these platforms, their impacts on our children, and how they are addressing these concerns. While I'm not offering this amendment today, I'd welcome the chance to work with my colleagues on this bill and to advance it in another committee at a future point. Thank you, Mr. Chairman.
Thank you, Senator Coons. I fully support your amendment. I think you understand that the committee jurisdiction issue is on our minds as we consider it. I certainly hope what we do today, if we pass this legislation, will inspire the other committees to take up the issue as well. Senator Blumenthal?
I strongly support the amendment and the goal here, which is also part of what we're trying to do, Senator Blackburn and I, in the Kids Online Safety Act, which is under the jurisdiction of another committee. And as I've indicated to Senator Coons, we want to work with you. Transparency is so important to knowing what is going on with these black box algorithms. And part of the power of big tech is that they alone have that knowledge and information. And the Kids Online Safety Act, with this kind of addition, I think will help liberate parents and kids.
Thank you. Anyone else seek recognition? If not, I would like to say a word before I call the vote on final passage.
Mr. Chair.
Senator Padilla?
Mr. Chair, not for purposes of amendment, but I would like to make a statement beginning with thanking you and your excellent staff for your hard work to address the exploitation and abuse of children. Clearly issues that demand our attention and action. And I want to compliment your engagement of all committee members in this process. Absolutely agree with the spirit of the legislation. I just want to highlight there are still some outstanding questions that I hope can be addressed as the bill moves to the floor. And I'll begin by reminding us of a comment I made last week as we discussed the Earn It Act. Want to work with you and others in the committee to ensure that the legislation allows us to go after the bad actors, but doesn't unintentionally impede access to encryption. I'm also nervous that some of the provisions of the bill may overwhelm and negatively impact NCMEC's operations. That's been discussed earlier in today's hearings. I'm also sensitive to the concerns that have been raised about the report and remove structure that could be challenging to navigate. And finally, I already had outstanding questions about the scope of conduct reached by your bill's changes to 18 U.S. Code Section 2255, as well as the new criminal provision created at 18 U.S. Code 2260B. Still reviewing the changes that you and Senator Hawley agreed to. We received the language just this morning. So just want to make sure that we get an opportunity to chime in on those as this bill moves to the floor. And finally, I'd like to consent to enter into the record a letter from the Internet Society, which details some of the concerns in more depth. I certainly look forward to working with you and your team.
Thank you, Senator Padilla. Senator Booker?
Thank you very much. For a second there, I thought you forgot my name. I appreciate that, sir.
I could never forget your name.
I thank you, sir. I first want to thank you for your continued leadership in this space. Not only is this noble, and to see the bipartisan collaboration is heartening. This is a scourge, not just in our country, but globally. And to see this coming together and folks working on trying to meet the gravity of this crisis, to me, is incredibly encouraging, and the progress that we're making gives me a lot of hope. I also want to affiliate myself to some extent with Senator Graham. I think these powerful companies have very little incentive right now to meet the crisis that's before us. Their profits, their power is extraordinary, and if we don't find a way collectively on both sides of the aisle to reel them in, to use their awesome technological power to stop this kind of heinous activity, I fear that the speed of technology, that even as we pass legislation, it's not going to be able to keep up. We have to find, as Senator Graham seems to be looking for, a way to bring them to the table as more willing, urgent collaborators. And so as this moves forward, though, I want to take you up on your continued offer through this whole process to work with you to find the balance that is so important. 10 years I've been in the Senate and have been, just like colleagues of mine on both sides of the aisle, wanting to stop all kind of heinous crimes. But I often find in the criminal justice space that we do good work, but there are unintended consequences that often the most vulnerable people, people who are often maligned or discriminated against, often get unjustly prosecuted. I want to thank Senator Padilla, who's been a great voice on this. I do worry about the LGBTQ community. I worry about, as our lives move more and more online, and we are doing things from even conducting medical processes, sending issues back and forth, as women are now finding themselves are targeted in terms of abortion access and more, that there could be unintended consequences. And so I gratefully accept your continued offer and encouragement to work with you to find that balance. And then finally, end-to-end encryption is a real issue. I know a lot of us in this room use encrypted platforms to communicate. We do it in the Senate all the time, end-to-end encryption, where there is no knowledge of the platforms we use, because I communicate with a lot of folks in this room on that, about what we're saying as Senate. I don't want them to know when we're having private conversations, when I can't track a colleague down, but send it through an encrypted platform. That is a real issue that Senator Padilla rightfully brings up, and I think we need to think about that. We are in a society now with AI, quantum computing. The technology is moving so fast, our lives are changing so much. What we do now is going to affect not just the current state of our country and the world, but it's going to affect innovations that are far down the road that we need to make sure that we are thinking through. So I cannot tell you how grateful I am for this markup, for your leadership in this space, and for your invitation to continue to work with you to find that balance.
Mr. Chairman,
Senator Grassley.
I want to follow up on what Senator Booker made in reference to what Senator Graham has previously said about the intimidation and the unwillingness of these people to work with us. I'm not talking just about your bill. I'm talking about the platforms generally. And just look at last time. They spent $40 or $50 million on television to defeat the Klobuchar bill, which was doing nothing more than tackling their economic discrimination. And we're all cowed by it now. The Klobuchar bill, as far as I know, isn't introduced yet because there's certain people that sponsored the last time are cowed by $40 or $50 million spent on television. And it's the same thing is up against your bill. And until we tackle that, we're not going to accomplish anything and bring the power of these people to kneel.
But he's not mad. This is just the way he talks.
Mr. Chairman. Mr. Chairman.
I want to bask in the glow of that comment from the senator from Iowa for just a few seconds more. Senator Klobuchar.
Well, I could not do justice to that passion, and I appreciate the plea for our bill, but I would like to say the latest number is $300 million spent in ads in individual states against individual members, red state ad, blue state ads that are very different just to get their way. And my colleagues that say they want to bring them to the table, the only way we bring them to the table is what Senator Hawley talked about. The only way we bring them to the table is what Senator Graham's been working on so long and making it clear we're not afraid of them and we're passing bills. And you made a big step today. Thank you.
Anyone else seek recognition? Senator Whitehouse.
Just a quick word, since Ranking Member Graham mentioned me in the context of Section 230 repeal. Obviously, we're going to have to work with everybody in this committee, and we look forward to working with everybody in this committee. But I just want to make the opening point that repeal of Section 230 does nothing more than revert to laws and principles that have stood the test of time. Many of them go back to the founding of this country. Many of them go back to ancient common law, adopted at the founding of this country and incorporated into our laws. We are a country of laws. We celebrate the rule of law, and there should be no need to fear the application of time-tested laws in this space. So I look forward to working with our distinguished ranking member, to hearing from and engaging with all of you. But I think the baseline proposition that the repeal of Section 230 is simply a reversion to a very stable, reliable, time-tested model that is the essence of what America is all about, rule of
law in which everyone has access to a courtroom for redress of injury.
Thank you, Senator Whitehouse. I'm Senator Welsh. Senator Ossoff.
Yield to you.
Thank you, Mr. Chairman. And I think this is this moment is a testament to your hard work. I know there were many who doubted that we'd be able to get to a place of bipartisanship on this legislation, and you've achieved that working with the ranking member and Senator Hawley and others. So congratulations and gratitude to you. Three quick issues I wanted to raise as this moves forward. And I first want to say I fully agree that opening the courtroom to parties harmed by misconduct is essential, and we're making progress toward that end. First, I just want to echo what Senator Booker said about encryption. We're going to have, I think, a broader conversation about this on an ongoing basis, because this is going to keep coming up. But this essential cybersecurity technology, just as we discussed during consideration of the Earn It Act, we would be wise to be diligent to ensure that we don't have the unintended consequence of breaking or denying access to it, where that's not our intent. Second thing I just want to flag is on this question of what constitutes an imminent criminal act, and when there are mandatory reporting requirements for what a provider may deem an imminent criminal act. There is a very compelling public interest and safety interest in ensuring that some of these heinous crimes can be prevented before they're committed. We also need to think carefully, I think, as we move through this process about when we may start to cross the line into asking providers to predict future crimes and to report people on that basis, because I think there potentially some due process and Fourth Amendment concerns may come into play. I think we're moving forward in a good direction. I just want to flag that as an issue that I think is not just relevant in this context, but a whole range of other forms of criminal conduct that may be implicated by other policies proposed like this one. And finally, the point about the interests of parents. Obviously, the overwhelming interest of parents here is to protect their children from online abusers. There have also been cases fairly widely reported where, for example, a parent in correspondence with a pediatrician has been swept into a legal black hole with risk of great reputational damage because that content was improperly flagged as the kind of content that we're trying to remove from the internet. I think that's a real concern for some parents, and a diligent consideration of how we avoid that unintended consequence would also be wise. Thank you, Mr. Chairman.
Thank you, Senator Welch.
Thank you. Coming new as a new member to the committee, but coming from Vermont, where we're all struggling with the extraordinary harm, mental health issues that are afflicting our young people, making parents really insecure about their well-being of their kids, and also feeling totally powerless as a family, as a small state. It's very heartening to me to see the extraordinary amount of work and attention and thought that this committee, both sides, have been giving to this issue that is gigantic. You mean the media companies didn't exist, now they are all powerful? And the dilemma here for us, the challenge, is to stand up to them. And if we're going to be successful in that, it's going to require us to do it together. And we also have to adhere to what have been time-tested values that Senator Whitehouse was referring to, but those include privacy, those include protecting vulnerable populations, and whatever it is we draft, we know very well can have unintended consequences. So bottom line here is I think the cause here is quite noble and necessary, and I'm going to be supportive, Senator, of your bill and many of the other efforts that colleagues are making. But I will be doing my part to try to make certain that we also protect those values of privacy and also vulnerable populations. So thank you very much Mr. Chairman, and all of my colleagues for your good work on this.
Thank you, Senator. If no one else seeks recognition, I'll make one closing comment before calling for the vote on final passage. I know a family in New York that has twins, a boy and a girl. They're 11 years old. This family is conscientious and caring for their children, and they worry every day what's going on the screens that these kids are looking into. They do their best to keep the screens away from them as much as possible, but it's a very difficult challenge to do that. I know this family because it's my daughter and her grandkids. My wife and I visited with them just a week or so ago, and I thought to myself, Senator, Chairman, for God's sake, what are you going to do for your own grandkids? So I sat down with them and said to them, do you know the danger of what you're holding in your hand, that smartphone and what it could do? And they told me they did, and they understood exploitation. And I was hoping that even at the age of 11, that they really did understand it and how it could be so harmful to them. I did what I thought was my responsible duty as a grandparent to say a few words. I don't believe mine was a unique situation. I think we all sense this and feel this feeling of helplessness, of how quickly this technology is overtaking our efforts here in this committee and in Congress. And the fact of the matter is, this industry knows how to lure children and knows how to convert children into things they should not be doing. They have algorithms that assist them and unfortunately empower them to do the wrong thing or the right thing. And we've got to accept that reality. Congress, and particularly the Senate, are notoriously slow in responding to trends and changes in America. Let's hope that this effort is timely enough to help some people and to go to the Grassley charge. I say not charge in terms of accusation, but charge in terms of an admonition. Shame on us if we pass this bill out of this committee, which I hope we do, and then let it founder on the floor. I mean, we have got to be a voice and a power to move some of these bills on the floor. If they are bipartisan, which is what Schumer's looking for, and they are, let's tell him, let's get down to business here. Nominations are important, but we should be doing something else with the nominations. I can't think of a measure we could enact that would have more positive impact with families across America, left, right, and center, than to give them these authorities and to create disincentives for those who would abuse and exploit these kids. So at this point, I'll call on final passage for a vote. On favorably reporting S 1199, the Stop CSAM Act of 2023, all those, let's have the clerk call the roll.
Mrs. Feinstein.
Aye by proxy.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Aye. Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Ms. Hirono. Aye. Mr. Booker. Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff.
Aye.
Mr. Welch.
Aye.
Mr. Graham.
Aye.
Mr. Grassley.
Aye by proxy.
Mr. Cornyn.
Aye.
Mr. Lee. Aye. Mr. Cruz.
Aye.
Mr. Hawley.
Aye.
Mr. Cotton.
Aye by proxy.
Mr. Kennedy.
Aye.
Mr. Tillis.
Aye by proxy.
Mrs. Blackburn.
No.
No. No by proxy.
Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 20, the nays are 1.
The majority of members present having voted in the affirmative, the ayes have it. The bill will be favorably reported to the floor. And at this point, is any further business to come before the committee?
Were we going to do our bill? Okay.
Next, we'll consider S 412, the SHIELD Act of 2023, sponsored by Senators Klobuchar and Cornyn, seeks to combat the non-consensual distribution of sexually intimate images, including what some people colloquially refer to as revenge porn. It does so by creating federal criminal liability for people who distribute others' private and explicit images online without consent. Excuse me. The bill also makes it illegal to distribute nude images of a minor with intent to abuse, humiliate, harass, or degrade the minor, or to arouse or gratify the sexual desire of any person. I'll now turn to the bill's sponsors, Senators Klobuchar and Cornyn, if they'd like to make remarks or offer their manager's amendment.
Thank you, Mr. Chair. I understand there may be amendments, so I'm going to go quickly here. I'd like to thank you and Ranking Member Graham for bringing this up. Been trying to get this done for years, and I especially want to thank Senator Cornyn for his leadership. We've worked together closely on this bill. I also want to recognize former Representative Katie Hill of California, who's been a tireless advocate to push this bill forward because of her own personal experience. This bipartisan bill gives law enforcement the tools they need to stand up for victims of serious privacy violations, an issue that has affected many people across this country. It's embarrassing, it's difficult to talk about, and maybe that's why it's often swept under the rug. One study found that 1 in 12 people reported having had intimate pictures shared against their will. These serious privacy violations have enormous impacts on victims. According to one survey, 93% of victims report suffering significant emotional distress due to having their intimate images shared. 82% report suffering significant impacts in their lives. 13% of victims report difficulty getting a job or getting into school because of the images, and 51% of victims have experienced suicidal thoughts as a result of the violation. That's why we need to provide victims of online abuse with the legal protections they need. Our bipartisan bill establishes narrow federal criminal liability for people who distribute others' private or explicit images online without consent. It also fills in existing gaps in federal law so that prosecutors can hold all those who exploit children accountable. Today, 48 states and the District of Columbia have laws criminalizing the non-consensual sharing of intimate images. It's beyond time for us to put similar protections in place on the federal level because, as we well know, online crimes are not bound by state lines. To ensure the bill receives broad support, we made a number of changes in the manager's amendment that respond to concerns raised by members of the committee. For example, we raised the mental state required under the bill from recklessness to knowledge. We also removed the civil forfeiture provisions and added language clarifying that reporting an unsolicited nude image is not covered under the statute. The bill is supported by, of course, victim rights and law enforcement groups, including the National Center for Missing and Exploited Children, the National Center on Sexual Exploitation, RAIN, the National District Attorneys Association, and the National Association of Police Organizations, to name a few. This legislation is a necessary step toward making sure that victims of serious privacy violations, since we have yet to pass a federal privacy law in the United States of America, it does protect victims of serious privacy violations and online abuse, have the legal protections they need, and that law enforcement has the tools to hold exploiters accountable. I urge my colleagues to support the bill.
Mr. Chairman.
Senator Cornyn.
Mr. Chairman, I want to thank Senator Klobuchar for her leadership on this. Senator Lee was an important partner in getting us to this point. This legislation, briefly, is important to protect child victims and to address serious privacy violations. It closes the gap where child exploiters distribute sexual and compromising images of children to lure other predators to harmful websites. So I would urge all of my colleagues to support this important piece of legislation in order to protect child victims.
Thank you, Senator Cornyn. Anyone else seek recognition? If not, I believe there's a manager's amendment. Is that correct?
That's correct. Submit the manager's amendment.
Question is on the adoption of the manager's amendment. All those in favor say aye.
Aye.
Those opposed, no. The opinion of the chair, the ayes have it.
Mr. Chairman, I'd like to be added as a co-sponsor.
Without objection, Senator Lee will be added as a co-sponsor. Anyone else? Unfavorably reporting the S-412, the SHIELD Act of 2023. All those in favor?
Are there going to be amendments?
Yeah.
Oh, I'm sorry. I thought that I gave you
If
that
not,
opportunity.
I'd also like to ask
It's not necessary.
I would like to offer an amendment, Mr. Chairman.
Senator Booker.
I really appreciate that.
And I have a question.
First, let me add Senator Whitehouse as a co-sponsor.
And Mr.
And
Chairman,
I'd like to be added as a co-sponsor.
Senator
No,
Blumenthal.
I have a question.
Oh, of course.
I have a question, and it has to do with the specific intent requirement. As I read the bill, it creates a specific intent requirement for pictures of adults. It does not have the specific intent required for pictures of minors, which seems to be the backwards of the way that should be.
It's actually the opposite.
As long as that's clear, then I'm comfortable. Rhode Island law requires specific intent requirements for pictures both of minors and of adults. And if that's clarified, then I will feel much better about the bill. Thank you.
And you'll be
Yeah, it doesn't include specific intent for adults, just to be very clear.
Senator
Only
Graham will
minors.
be added as a co-sponsor. Senator
Mr. Chairman.
Whitehouse already is a co-sponsor. Senator Blumenthal as well. Any others?
Mr. Chairman, I'd ask to be added as
Senator
a
Cruz.
co-sponsor.
Senator Cruz, co-sponsor. Any others? Or any other amendments? Senator
A
Coons?
question, if I could, Mr. Chairman. Just, I intend to work with Senator Klobuchar and Senator Cornyn to make sure that I better understand the definition of reporting, of essentially innocent reporting that's been added, and the impact of the intent provisions of this bill. Delaware is a state that has a structure that I think makes sense out of the many states that have statutes criminalizing revenge porn. Revenge porn or the harmful, traumatizing posting of inappropriately explicit images is abhorrent and something we should take action against. And I appreciate the efforts, the leadership by Senator Klobuchar and Senator Cornyn on this and many other issues. I'm just concerned that as drafted, it could potentially make a felony out of good faith or innocent conduct by adolescents who receive and forward images, and I want to make sure I better understand that. In Delaware, our statute has no intent requirement for a misdemeanor charge and adds either 4 aggravating factors or an intent requirement for a felony charge. And I think it is exactly that sort of boundary between misdemeanor and felony that is about to be debated in some amendments. In Delaware, the aggravating factors are distribution for profit, pairing the image with personally identifiable information, maintaining a website to host such depictions, or obtaining without consent through hacking. I think these are good factors, and the balance between misdemeanor and felony makes sense. Obviously, I think Delaware got it right, but I want to work with the co-sponsors of this to make sure that I fully understand the direction they're going with intent and with that boundary line between misdemeanor and felony.
Mr. Chair, we look forward to working with Senator Coons, and I know we have made several changes and can continue to make changes to make sure everyone's comfortable with the bill.
I believe Senator Booker said he has it. Senator Padilla first.
Thank you, Mr. Chair. Just in a similar vein to Senator Coons' remarks, I want to also begin by thanking the sponsors of the bill for bringing the much-needed attention to a critical issue at the intersection of speech and privacy. Also informed by California law, as California and other states have already passed laws at the state level on this topic. I want to ensure that we're incorporating the lessons that have been learned by these various state models into our deliberations. Now, it's my understanding that as currently drafted, there's some amendments that may potentially address this today, potential offenders must only have knowledge of a lack of consent when sharing a person's intimate image. But there's no requirement that the person receiving the image and subsequently sharing it have any requisite intent to cause emotional distress or suffering. Now, I know this is a complicated issue, but I want to make sure that we don't unintentionally subject individuals to criminal charges due to the lack of an intent requirement. For example, right, instead of talking legalese, let's point out some examples to shed light on some of the complications and tensions here. It's possible that we can be creating a gap in accountability for people who send unsolicited sexual photos of themselves while creating a hard and fast punitive consequence for those who receive the images and subsequently share the image. So here's the real-world example. I'm sensitive to people who receive unsolicited photos and want to share that they're receiving a disturbing text, for example, with a therapist or trusted confidant. The bill as drafted would appear to criminalize this conduct. So if the bill were to move forward today, I would certainly hope to continue to working with you and the sponsors of the bill as this, if this were to move to the floor. Thank you, Mr. Chair.
Thank you, Senator Padilla. Senator Klobuchar, do you like to respond?
Yes, I just would warn people that if you take the definition, and Senator Cornyn and I have made changes and listened to many members on the committee and have made changes, but if you go too far, for instance, Georgia's statute includes a requirement that prosecutors prove an intent to harass. But in that state, according to public records, there has been only one prosecution for this crime in 10 years because of where the standard's set. So we have looked to set the middle ground, and we look forward to working with our colleagues on that going forward.
Before I recognize Senator Booker, Senator Blackburn's office has advised us there was a miscommunication, and she would like to be recorded as voting aye on the CSAM Act. And I ask unanimous consent that the clerk's records be changed to reflect her aye vote and a unanimous vote by the committee in favor of the CSAM. Is there any objection? No objection. Senator Booker?
Again, Senator Klobuchar, I'm grateful for her leadership. She has been extraordinary in this space, as have other of my colleagues, and I want to thank Senator Cornyn for his leadership on this as well. I have an amendment that I was going to offer on intent, and I know I had a few folks who would support such an amendment. I do not have the necessary votes to pass it, but hearing the conversation and the dialogue of some of my other colleagues on concerns around this intent, my hope is that we can continue to work on it. I do not think the balance is struck right now, and my hoping, I'll withdraw my amendment with hope that Senator Klobuchar would be willing to continue to work and take input on trying to find the right balance.
Of course. I appreciate that, Senator Booker. And I will note that in response to feedback, the manager's amendment removed language from the bill that would have allowed prosecutors to bring cases when a defendant recklessly, instead of knowingly, shared an intimate image. And my goal here is to make sure, and we've heard this from offices across the country, state offices, that whatever intent requirement we end up at, we don't want one that would be impossible for prosecutors to prove and make it so that we're not really doing anything.
Senator Booker.
I'm grateful. Senator Klobuchar, and I want to note, she's made multiple changes in this bill based upon the input, not just from my office, but from other offices. Obviously, Senator Cornyn and his team have been involved in that, and this is an extraordinary process, and we're grateful for that. I have one more issue that I want to bring up. The bill would also criminalize, and not intent, but criminalize an attempt to distribute non-consensual intimate images and to conspire to do so. In the context of distributing an image, it is the sharing that causes the harm. It is actually posting and sharing that causes this egregious, horrific harm to folks' lives. And we know that once you put these images up, the harm stays stays out there. It's hard to remove them. However, I didn't find one case law, any case law, that interpreted attempt in statute. And I believe that no one has been able to offer an example of what an attempt looks like. It's vague. It's a vague attempt idea. Attempt to distribute, because of its vagueness, opens the door, I believe, to prosecutorial abuse and possibly unfounded allegations. The bill already makes threats to distribute these images a crime equal to actual sharing of the issue. So threats, I understand. The approach acknowledges and accounts for instances that more closely resemble attempt and adequately address that in some cases. But this idea of conspiracy is also superfluous, as a person is criminally liable and subject to the same sentence as the co-conspirator under accomplice liability. So seeing this area of criminal law play out in unintended consequences, I have an amendment that would deal with this, what I think is vague attempt and conspiracy. I'm willing to combine that with another issue I have, which is that the bill creates a felony offense punishable up to 5 years in prison. Every state in state law addresses this. 31 states have a penalty of a year or less. 12 states have a penalty of 1 to 3 years. Now, we know the federal penalty for assault by beating, physical assault by beating, is a 1 year maximum. The federal penalty for the sale of obscenity is a 2-year maximum. The federal penalty for abuse, sexual contact with a minor carries a 2-year maximum. A 5-year sentence, I believe, is out of proportion with state and federal laws and should be aligned with the majority of states. I say this understanding that New Jersey's penalty, we were a first mover in this space in 2003, is 5 years. We're one of the outliers. But that was before Twitter. It was before Facebook. It was before this area emerged to become the kind of area we are. So I'll combine those two, this, what I think the vagueness of attempt and the penalty area into one amendment. This is an area I think is important. I don't think the votes are there, but I would like to call a roll call on my amendment in this case. And I think if I have it right, it's LIP 23476.
Yep.
So pending before the committee is Amendment LIP 23476 by Senator Booker. Does anyone wish to respond to his offer?
I will, and I appreciate it. I would hope we could try to work this out, but I will respond. The first thing is on attempt. I think my colleagues are aware the word attempt appears throughout the criminal code with regard to other types of crimes. It's not a new concept. In this case, these provisions allow prosecutors to bring charges against people who would knowingly upload harmful images to online peer-to-peer distribution systems where it's very difficult to prove whether any particular image was actually downloaded. They're attempting, they're trying to put it into these peer-to-peer distribution systems and with intent, clearly, to hurt someone. For example, also, in cases involving images of minors, prosecutors have emphasized to us that provisions like these have also allowed them to bring charges against those who attempt to give it to an undercover officer. And so that's why we included these attempt and conspiracy provisions, because while they're not the focus of the bill, they are a very important tool for law enforcement, which has had difficulty enforcing these provisions. As for the penalty, I guess it depends how you look at it, and I certainly appreciate Senator Booker's perspective on these, but I would like to remind my colleagues this is not a minimum penalty, this would be a maximum penalty, and judges have the discretion to tailor sentences to the seriousness of the crime. The penalties included in this bill are consistent with or actually substantially less than the penalties of other significant privacy violations currently in law, from identity theft to accessing a computer without authorization. The 5-year penalty under our bill for distributing images of nude minors is significantly less than the severe penalties that exist for other crimes involving distributing nude images of minors, some of which allow for up to 20 years in prison. That's why we settled at the 5 years. I don't know if you want to add anything, Senator Cornyn.
Mr. Chairman, I can't improve on what Senator Klobuchar just said.
It's a very stark admission. Thank you very much, Senator Cornyn. Anyone else wish to speak on the
I said
Booker?
what she just said.
The record will be clarified. So the question's on the adoption of the Booker Amendment. Senator Coons.
I'll just briefly say I look forward to working with the lead co-sponsors on some of the aggravating factors and better understanding, in my view, the range and how look, Senator Klobuchar is an experienced prosecutor. I am not. I'm simply saying that I think the idea that a 5-year felony sentence is possible with aggravating factors makes sense to me. I just want to make sure I fully understand those implications. Thank you.
No one else seeks recognition. The question is on the adoption of the Booker Amendment. Does Senator wish a roll call?
Please.
The clerk will call the roll.
Mrs. Feinstein.
No by proxy.
Mr. Whitehouse. No. Ms. Klobuchar.
No.
Mr. Coons.
No.
Mr. Blumenthal.
No.
Ms. Hirono. Aye. Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff.
Aye.
Mr. Welch.
Aye.
Mr. Graham.
No, by proxy.
Mr.
No by proxy?
Mr. Cornyn?
No?
Mr. Lee?
No.
Mr. Cruz?
No.
Mr. Holly? No. Mr. Cotton?
No by proxy?
Mr. Kennedy?
No.
Mr. Tillis?
No by proxy?
Mrs. Blackburn?
No by proxy?
Chair Durbin?
No.
Chair Durbin, on this vote, the ayes are 6, the nays are 15.
The amendment is not agreed to. Are there any further amendments? If not, vote on final passage on 412, SHIELD Act of 2023. The clerk will call the roll.
And we don't need to have a roll call if you don't.
Okay,
We
so
can
the
just do-
question
if-
is on the-
Unless someone wants one, it's fine.
Anyone seek a roll call vote? If not, we're going to take a voice vote. All those in favor say aye.
Aye.
Those opposed, no. The majority of members present having voted in the affirmative, the ayes have it. The bill will be favorably reported to the floor. Next, we will consider S 1170, the Project Safe Childhood Act, sponsored by Senators Cornyn and Klobuchar. Do the sponsors wish to explain the bill? Senator Klobuchar.
I'd like to thank you, Chair, Ranking Member Graham, for listing the Project Safe Childhood Act for markup, as well as Senator Cornyn, and so many of the other sponsors, including Grassley, Blumenthal, Blackburn, Murphy, Graham, Ossoff, Tillis, Welch, Hawley, and Feinstein. As you know, the Project Safe Childhood Initiative at the Justice Department has helped to combat child sexual exploitation. Thousands of kids depicted in child sexual abuse material, or CSAM, have been identified. In 1 year alone, this is a shocking statistic, federal prosecutors obtained more than 3,000 indictments for child exploitation offenses. With rapid changes in technology, it is critical that we modernize this program. This bipartisan legislation makes important updates to Project Safe Childhood to ensure that federal prosecutors and law enforcement are working together to stop child exploitation online, training protocols to help law enforcement, and giving prosecutors and law enforcement tools to target offenders. Common sense updates supported by National District Attorneys Association, National Association of Police Organizations, RAIN, Fraternal Order of Police, and National Center for Missing and Exploited Children. I urge my colleagues to support the bill.
Thank you, Senator Klobuchar. Senator Cornyn.
Mr. Chairman, I want to thank Senator Klobuchar for her good work and partnership again on this important bill, Project Safe Childhood Act. It improves coordination between state and local and federal law enforcement, both in individual districts and at the Department of Justice, to better fight online exploitation of children. We have to do better. I have a manager's amendment for the bill, and I'd like to offer that at the appropriate time. By way of explanation, the manager's amendment strikes Section 3 and 4, which made important technical corrections to the child exploitation criminal statutes. I agree to strike these not because I don't believe they are important, but because I'm committed to the good faith bipartisan legislative process. So I look forward to moving the Project Safe Childhood Act out of committee and towards the floor. And to that end, I would ask unanimous consent that the manager's amendment be adopted.
Without objection, the manager's amendment is adopted. All those in favor
Mr.
say
Chairman?
All
Mr.
those in
Chairman.
favor,
Could I request addition as a co-sponsor, please?
without objection, Senator Cruz will be added as a co-sponsor. And I'd like to be added as a co-sponsor to both 1170 and 412 without objection.
Mr. Chairman?
Chairman, I have,
Make sure we adopted
Senator Cruz.
I'd like to be added.
Manager's amendment is adopted. Senator
Thank you.
Cruz,
I'd like to be added as a co-sponsor
added
as
as
well.
co-sponsor without objection.
So if I can just conclude by saying projects, now that the manager's amendment has been adopted, that Project Safe Childhood is an initiative from the dawn of the modern internet, a response to growing realization that we faced a major online problem with exploitation continues today, and obviously seems to be the theme of today's markup. This updates and modernizes the law to respond to the challenges that our children and we as a society are facing today. The strategic protocols and case coordination this bill requires will give law enforcement tools they need. I think this bill will have concrete positive effects in our efforts to protect our children from being victimized anywhere, including on the internet. And again, I appreciate the strong support Senator Klobuchar and I have gotten from Senator Grassley, Senator Blumenthal, Senator Blackburn, Senator Graham, Senator Ossoff, Senator Tillis, Senator Welch, Senator Hawley, Senator Feinstein, Senator Kennedy, and Senator Cruz as co-sponsors. And I would urge others to co-sponsor it as well and would appreciate an affirmative vote.
Senator Klobuchar.
Thank Senator Cornyn for his leadership on the bill.
Anyone else seek recognition on this bill?
Mr. Chairman,
Senator Hirono.
can you add me as a co-sponsor in response to
Hirono
Senator Cornyn's request?
Senator Hirono's name will be added. Senator Ossoff.
It's been a pleasure to join the team that's been leading the charge here as a co-sponsor of this legislation to empower the Department of Justice to crack down on those who are exploiting children online. I thank the sponsors, and I'm grateful the committee's taking this up today. Thank you.
Mr. Chairman, we'd be happy to have a voice vote.
We'll have a voice vote in just a moment. I want to welcome back our colleague, Senator Dianne Feinstein. So the question is on the passage of S 1170 as amended. All those in favor say aye.
Aye.
Those opposed, no. Opinion of the chair, the ayes have it. The majority of members present having voted in the affirmative, and the bill will be favorably reported to the floor. We have 2 or 3 nominations. Charnel B.L. Kindgren, nominated to the Eastern District of Washington. Does anyone seek recognition to speak on her nomination? Senator Cruz.
Thank you, Mr. Chairman. I'm glad to welcome our colleague, Senator Feinstein, back to this committee. But I will say what's going to happen next, I think, is going to be quite unfortunate for the American people. Because what we're about to see this committee do is vote on several nominees who are so extreme, who are so unqualified, that they could not have a prayer of getting even a single Republican vote on this committee. And as everyone knows, Senator Graham votes for most of Biden's nominees. It is unusual that Senator Graham does not give a Republican vote to a Biden nominee. But there's a small subset of these nominees that are so beyond the pale that they have no prayer of getting a Republican nominee. And frankly, if my Democrat colleagues valued the responsibility of the Senate's advise and consent, my Democrat colleagues would tell the White House these nominees are unacceptable. This first nominee, Charnel Beckelgren, is so amazingly unqualified, she may well have the title for the least qualified nominee I've seen in 11 years serving on this committee. When Senator Kennedy asked her what Article 5 of the Constitution was, she had no idea. When Senator Kennedy asked her what Article 2 of the Constitution was, she said, I don't know. Mind you, Article 2 is the provision of the Constitution that creates the president and the executive branch of the government. Any first-year law student that didn't know what Article 2 of the Constitution was would flunk con law. This is not some obscure question about some Latin phrase no one should know. This is literally the basic architecture of our Constitution. By the way, Joe Biden has nominated her to be an Article 3 judge. Article 3 is right after Article 2. It creates the federal judiciary. I assume she doesn't know what that is either. I would note that the chairman, in defending her, suggested, well, gosh, there may be some members of our committee that don't know what Article 2 is. I feel confident that's not true, but if there is on either side of the aisle, you should stand up and resign the committee right now. To give you a sense of how unqualified this nominee is, she listed in her judiciary questionnaire her top 10 litigated cases. And I just want you to pause and read this for a second. Her top 10, she did a driver's license revocation. She did a second driver's license revocation. She did an unemployment benefits appeal. She did another unemployment benefits case. She did another unemployment benefit case. And her sixth case was an unemployment benefits case where on the opposing side was a pro se litigant. In other words, This poor fella didn't have a lawyer. And you know what? The pro se litigant beat her. She lost to a pro se litigant. What's her 7th most consequential case? I'm sorry, there isn't one. There's not an 8th, there's not a 9th, there's not a 10th. She's argued over a couple of driver's licenses, and the Biden White House says you should be a federal judge, an Article 3 judge, not that you have any idea what in the hell that is. In this administration, if you are a left-wing radical, it doesn't matter if you're competent. In Washington state, is there not a single competent lawyer who is competent to be a judge? And by the way, for all the Democrats, since Joe Biden has become president, every one of you has rubber-stamped every single nominee. Is there not a one of you that is willing to say enough is enough? When Donald Trump was president on the Republican side, we confirmed some fantastic judges, but there were several we sent back that we said, no, you missed it on this one. There's not even one Democrat willing to say enough is enough. And by the way, she's not the only one. Another one being considered, a nominee, Cato Cruz. Thankfully not spelled C-R-U-Z, spelled C-R-E-W-S. When asked about Brady versus Maryland, one of the foundational criminal law classes, again, first-year criminal law, you learn about Brady. She said, I'm sorry, I don't know what Brady is. That'll be a problem if she's ever presiding over a criminal case. There are a number of members of this committee who have tried criminal cases. Do you know what Brady is? Of course you do. Because if you're remotely competent, you know what it is, not this judge. Look, sadly, the standard for nominees now seems to be licensed attorneys in Washington. Have you ever handled a criminal case? You ever tried a jury trial? Have you ever stepped foot in federal court? Well, then please contact Senate Democrats, because you too can be a federal judge. I want to end with one more nominee that we're getting ready to ram through on party line votes. That is Judge Marian Gaston, nominated for a seat in San Diego. Judge Gaston, look, we've seen some radicals. We had a nominee earlier that this committee rubber stamped who said he woke up every morning motivated by his hatred for conservatives. Senate Democrats says, sounds like a judge to me. But let's see just how moonbat crazy we're willing to put on the bench. Here's a quote from Judge Gaston. Children are not safer because registered sex offenders are prohibited from residing near schools, parks, daycare centers, and other places where children tend to gather. And in fact, Judge Gaston continued, let's go to the next one. Judge Gaston continued, the conclusions and recommendations are that, difficult as it might be, so at least Judge Gaston recognizes this is pretty wingnut, the conclusion, laws that regulate where sex offenders may not live should be repealed or substantially modified in the interest of public safety. So I want you to understand the Joe Biden White House is saying a radical who wants sex offenders, who wants pedophiles to be able to live next door to daycares. That's who should be a federal judge. Look, some of y'all here represent blue states. Many of y'all represent blue states. I guarantee you in any one of your states. You go to Vermont, ask the people of Vermont, hey, what do you think about having a pedophile live next door to an elementary school, to a kindergarten, to a daycare? They'd look at you and say, are you out of your mind? That's who the Biden White House has given you. Now, I genuinely don't understand why Senate Democrats on this committee don't have enough respect for the constitutional role of the Senate to exercise some check and balance on the White House. I don't think they'll make you hand in your card-carrying Democrat cards. to say, gosh darn it, we ought to have a judge who knows what the heck he's doing. John Kennedy has left bloody carcasses in this hearing from Trump nominees who didn't have sufficient experience to do the job. I ask my colleagues, if you vote for these nominees, you're going to have to defend them to your constituents. You're going to have to explain why a lawyer who handled a couple of driver's license revocations and doesn't know what Article 2 of the Constitution is should be a federal judge in charge of your life, your rights, and the law. And you're going to have to explain why you think it's a great idea that sex offenders and pedophiles should live next door to daycare centers. I think that's nuts. And I think most of our constituents do too.
Mr. Chairman.
Senator Lee.
Mr. Chairman, I too have concerns with this nomination. I've spoken more than on a few occasions about various nominees, people nominated to the courts by President Biden. And in some instances, I've raised concerns in particular about their qualifications. We've had some who have either refused to answer, but more commonly proven unable to answer really basic questions about elementary principles of civil procedure, the Sixth Amendment, the rules of evidence, and even the Constitution. It's concerning on a number of levels. Look, it's not as though there were a shortage of lawyers in America. It's not as though there were a shortage of well-qualified lawyers in America, people who have practiced before federal courts routinely through the course of their profession. Nor is it difficult to find lawyers who are well-qualified based on many years of practice before various federal courts, including in many instances the court to which they've been nominated, who are themselves ideologically compatible with this administration. Legal academia in the United States leans a particular direction, and it's not toward conservatism. So it's not hard to find people who are compatible with this administration's approach to statutory construction, to jurisprudence as a whole, who are also well qualified. That's why I find some of this confusing. And of all the nominees who couldn't answer the most basic of constitutional questions, Judge Belkengren may well take the cake. Again, when asked by Senator John Kennedy, she admitted that she wasn't familiar with Article 5 of the Constitution or with Article 2 of the Constitution. If I'm not mistaken, she said something to the effect that, I haven't litigated over those things. Well, most people haven't litigated over them. They're essential to understand nonetheless. They're critical parts of the Constitution. And it's not as though the Constitution contains that many articles. It's stunning that she couldn't even comment on the subject matter of those foundational constitutional provisions. One doesn't have to have litigated on those things to know what they are and to be expected to know what they are. Look, I wouldn't hire a law clerk who couldn't answer those basic questions. And so I certainly can't fathom supporting a federal judicial nominee for a lifetime appointment as a federal judge who can't. Now, let's stop and remember here for a minute what a federal judge is and does. It's not just that it's a lifetime appointment. It's a lifetime appointment for a job that will impact people's lives, livelihoods, freedom, whether they go to prison, whether they win or whether they lose, on a wide variety of topics. Federal judges are required to be generalists in a very real traditional sense. They're required to have a pretty significant, deep understanding of the federal rules of civil procedure and the federal rules of criminal procedure, the federal rules of evidence, and they need to know their way around the U.S. Code. And certainly they need to be familiar with the basic elements of the U.S. Constitution. Anyone who's ever practiced before any court, especially the federal courts, as I have, has experienced what it's like to appear before a judge who is less qualified than other judges. And to describe it as a painful experience to everyone involved, especially those represented by the lawyer, is a vast, vast understatement. So we're not just being petty here in raising this concern. This will have real-world implications that can be very painful, that can be very devastating. Most people don't want their case handled, tried, adjudicated by an inexperienced judge any more than they would want to get a root canal performed by someone who doesn't know how to practice dentistry. And so this really is concerning. I know this administration can do better, and I expect this administration to do better. There is no shortage of people capable of doing this. There's no shortage of nominees who know what Article 2 and Article 5 of the Constitution are. There's no shortage of nominees, even who share the president's worldview, who haven't tried publicly to shame a 15-year-old victim of sexual abuse. There just isn't. You don't have to do this. Now, as to the suggestion, I'm sure it's coming because it's come every time we've raised concerns in the past. Suggestion is going to be, well, you don't raise these concerns when a Republican president is in the White House. That's not true. We did. I personally voted against a number of them who weren't qualified, who had issues. I personally, on occasion, would even reach out to the White House and said, what are you doing? This doesn't work. I'd urge each of you to do the same. Just think of the litigants in your respective states and across America who will be negatively impacted by someone who not only doesn't know their way around the courtroom, but doesn't understand the law. We can do better, and I expect the White House to do so.
Anyone else seek recognition? Senator Padilla.
Thank you, Mr. Chair. I wasn't going to speak, but since one of the nominees from California has been specifically pointed out, I feel an obligation to respond to the attacks, frankly. Judge Gaston is an experienced, highly qualified nominee who has already served as a judge in California since 2015. Prior to her service on the bench, she served as a deputy public defender in San Diego. Judge Gaston has presided over more than 500 trials, including hundreds that have dealt with abuse and neglect of children. And during that time, she is dedicated to the protection of abused and neglected children, and members of the legal community, including child advocates, have praised her for her work to protect particularly vulnerable children. She also spent 3 years presiding over San Diego Superior Court's Resilience is Strength and Empowerment Court, also known as the RISE Court, which serves youth survivors of commercial sex trafficking, ensuring their safety and that their educational, psychological, and physical health needs were met. As part of this work, she also instructed state officials, including law enforcement, on how to best serve and protect children in the courtroom. And I lay all this out, Mr. Chairman, because it is patently incorrect to suggest that a position paper that Judge Gaston co-authored 15 years ago argues that sex offender registries do not keep children safe. Now, I understand the paper is being twisted in bad faith to suggest that Judge Gaston was diminishing the importance of sex offender registries and other laws related to sex offenders, but that is not what it said. What the paper actually did was make several public safety arguments, which, by the way, were supported by local prosecutors, as well as parole and probation groups, and grounded in research. Imagine that, grounded in research about how we can best ensure the safety of our children from sexual abuse by keeping sex offenders off the streets. And specifically, the paper that's being referred to argues that children may be less safe due to the unintended consequences of sex offender residency requirements, which push sex offenders into homelessness. Once a sex offender does no longer have a residence, it is impossible to track them and protect our children. I have entered into the record 4 support letters for Judge Gaston, and I will read from just a few of them to help further make the point. First, from a letter from presiding judge of the San Diego Superior Court, Judge Michael Smith, quote, her commitment to public safety, the protection and welfare of children, and the rule of law. He is writing in her support. Second, a letter from retired Superior Court judge and former district attorney, Bonnie Dumanis, who said that while the residency restrictions at issue in Judge Gaston's position paper were well-intentioned, all of us who care deeply about protecting victims of sexual assault came to realize there were harmful unintended consequences of adding residency restrictions that would not protect from further offending, but would cause those required to register to go homeless and register as transient. And finally, a letter from one of her former colleagues in the district attorney's office, Attorney Phyllis Shess, outlines in his letter of support that the position taken by the paper was not radical, and in fact, California law now provides for individualized residence restrictions rather than exclusion zones as the paper recommended. So I get into this level of detail, Mr. Chair, just to reiterate the point that the paper being referenced is a result of nothing other than a common sense position, advice, recommendation to state officials supported by members of law enforcement, child advocates, and judges. The letters also demonstrate just how very well regarded Judge Gaston is in the Southern California legal community and what an asset she will be on the federal bench. Thank you, Mr. Chair.
I'd like to say, in response to the comments made on the Republican side about the other 2 nominees, the ABA rated Judge Bjelkengren qualified to serve on the district court. As a Washington Superior Court judge, she presided over 130 jury and bench trials. As an assistant attorney general for the Washington Attorney General's office, she tried more than 150 cases. Judge Cruz was rated unanimously well qualified by the American Bar Association. During his 17 years in private practice, he tried 18 cases to verdict, including 15 as sole or chief counsel. 2018, unanimously appointed by the active duty district judges to serve as a magistrate. In his time on the bench, he's already issued more than 1,700 recommendations and orders and has presided over 5 jury trials. These nominees' records as litigators and as judges are the best indicators of their abilities. Our response during the hearing does not negate, one response during the hearing does not negate a lifetime of service. Justice Amy Coney Barrett had trouble with a question. She was asked to name the 5 freedoms in the First Amendment. She could not do that. Yet she was quickly dispatched to the Supreme Court with every Republican voting in favor of her nomination. Senate Republicans clearly did not take that misstep to be an indicator of her abilities. They confirmed her to the highest court in the land. And I might note when she was up for circuit judge, she was asked to list the prominent cases in her legal background. She was given an opportunity to list 10. She listed 3. Since the 1980s, the ABA has rated a total of 22 judicial nominees not qualified to serve as federal judge since 1980. President Trump accounted for 10 of these nominees, 8 of whom were ultimately confirmed with strong support from Senate Republicans. So I just say that when it comes to nominees' trial experience and answering questions, there is not a consistent record on the other side.
Mr. Chairman.
I'm going to recognize the senator from Texas again, but I ask him to please let us get to a roll call.
So I'll say 2 things briefly. Number one, Mr. Chairman, you've just made a very powerful and effective indictment of the ABA and its role in judicial confirmations. You're right, the ABA has been wildly partisan, so they routinely find Republican nominees to be unqualified, even when they have decades of experience and very significant experience. And I got to say, if the ABA tells you that if you don't know what Article 2 of the Constitution is, and you've only tried 7 cases, mostly driver's license revocation cases, you're qualified to be a federal judge? Well, then the ABA ought to get out of the business of rating judges. And I'll just ask my colleagues something. Every one of you, answer this question to yourself seriously. If you were interviewing a chief counsel, all of us have chief counsels on this committee, if you're interviewing a law clerk, and the interviewee, if you asked that interviewee, what's Article 2 of the Constitution, and that person said, damned if I know, would you hire him? You all know the answer is no. None of you would hire someone who didn't know what Article 2 was to be a law clerk on your judiciary staff, and yet you're all prepared to rubber stamp this person as an Article 3 judge. Let me say secondly, very briefly, I understand why the senator from California wants to distance himself from the record of Judge Gaston, and he suggested that her report was, I think the language he used was common sense recommendations. Well, you know, John Adams famously said facts are stubborn things, so I will point out, I have that report right here in my hand. It is called Position Paper on Sex Offender Residence Restrictions. So it's all about where can sex offenders live? Can they live next to schools? Can they live next to kindergartens? Can they live next to daycares? Yes or no? Judge Gaston helped author it, and the verbatim quotes, quote number 1, quote, children are not safer because registered sex offenders are prohibited from residing near schools, parks, daycare centers, and other places where children tend to gather. Quote number 2, the conclusions and recommendations, in other words, what they're saying in this report, are that, difficult as it might be, laws that regulate where sex offenders may not live should be repealed or substantially modified in the interest of public safety. Mr. Chairman, I ask unanimous consent that the entire report be entered into the record so that people can read it and see that it says exactly what I'm quoting from.
Without objection.
And I have to say to my friend from California, if saying sex offenders should be allowed to live next door to daycare centers is common sense, then that's a very different definition of common sense than most people in Texas, and I suspect most people in virtually all of our states.
So I've given latitude in speaking to those who wanted to speak to these nominations, and at this point I'm going to call for the vote. Charnel Bjelkegren nominated to the Eastern District of Washington. The clerk will call the roll.
Mrs. Feinstein.
I ask to be recorded as voting in person on the 3 nominees considered earlier, Mr. Chairman.
Without objection.
Aye now.
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Go ahead. Go ahead.
Mr. Coons. Aye. Mr. Blumenthal.
Aye.
Ms. Hirono. Aye. Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff. Aye. Mr. Welch. Aye. Mr. Graham.
No.
By proxy.
Mr. Grassley.
No. By proxy. Vote by proxy.
Mr. Cornyn.
No.
Mr. Lee.
No by proxy.
Mr. Cruz. No. Mr. Hawley.
No by proxy.
Mr. Cotton.
No by proxy.
Mr. Kennedy.
No.
Mr. Tillis.
No by proxy.
Mrs. Blackburn.
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, I'd like to be recorded as a present for yes.
Physically present, voting yes.
Chair Durbin, on this vote, the ayes are 12, the nays are 10.
The nomination will be favorably reported to the floor.
11.
12 to 11. Nomination will be favorably reported to the floor. Next is Cato Cruz, nominated to the District of Columbia. The clerk will call the roll.
Mrs. Feinstein.
Aye.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Aye. Mr. Coons. Mr. Graham,
No by proxy?
Mr. Grassley,
No by proxy?
Mr. Cornyn,
No?
Mr. Lee,
No by proxy?
Mr. Cruz,
No.
Mr. Holly,
No by proxy?
Mr. Cotton,
No by proxy?
Mr. Kennedy. No. Mr. Tillis,
No by proxy?
Mrs. Blackburn,
No by proxy?
Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 11, the nays are 10.
The nomination will be favorably reported to the floor. Next is Marion Gaston, nominated to the Southern District of California. The clerk will call the roll.
Mrs. Feinstein.
Aye.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Aye. Mr. Coons. Aye. Mr. Blumenthal.
Aye.
Ms. Harona. Aye. Mr. Booker.
Yes.
Mr. Padilla.
Aye.
Mr. Ossoff. Aye. Mr. Welch. Aye. Mr. Graham.
No by proxy?
Mr. Grassley.
No by proxy?
Mr. Cornyn.
No?
Mr. Lee.
No by proxy?
Mr. Cruz.
No.
Mr. Holly.
No by proxy?
Mr. Cotton.
No by proxy?
Mr. Kennedy. No. Mr. Tillis.
No by proxy?
Mrs. Blackburn.
No by proxy?